Our next speaker is our last speaker for today. I'd like to introduce John McHugo, a trustee of the Balfour Project and a trustee of the Council for Arab-British Understanding, CABU, a close partner of those who care about the Arab world. John is a lawyer, an Arabist, a historian, author of several books, including A Concise History of the Arabs, Syria, A Recent History, and A Concise History of Sunnis and Shi'is. And he's working on a further book now. The theme that John is addressing today is the legal vacuum Britain created, how Britain failed in its sacred trust of civilization towards the Palestinian people. Welcome, John, and over to you.
Thank you very much, Vincent. Please, can I have my first caption put up on the screen, please? I'm going to talk to you, but I'm afraid I'm going to be using documents quite a lot. And this one, in a way, is the key document I'm going to be talking about. So although I'm not going to come on to it for the moment, I thought it would be there so you can just sort of let it infiltrate gradually into your brains, and you can ask yourselves what it actually means, but we'll come to it soon enough. To go back to the time of the First World War, Britain wanted Palestine for its own imperial purposes, to strengthen its control of the Suez Canal, to provide a land bridge from Egypt to Iraq, and to fulfill its promise in the 1917 Balfour Declaration to facilitate the establishment in Palestine of a national home for the Jewish people. These three purposes complemented each other. As Chaim Weizmann, then the emerging leader of the Zionist movement, had put it in 1914, shortly after the start of the First World War, he put it, a Jewish Palestine would be a little Asiatic Belgium. This would mean England, and I quote here, England would have a very effective and strong barrier to protect the Suez Canal, and we would have a country. When the Allied powers acceded to Britain's wish to possess Palestine, they did not consult its people who wanted independence in a form to be chosen by themselves, and they did not want their land to be ruled by Britain. So there was a haggle, and the other Allied powers extracted a legally binding quid pro quo from Britain. This was set out in the Charter of the League of Nations. This was that Britain committed itself to a sacred trust of civilization for the well-being and development of the people there. This meant preparing them for independence, and the result was the Palestine Mandate. Now, about 3 decades later, on the 14th of May 1948, when the mandate only had hours left to run, a telegram travelled from the Foreign Office in London along the undersea cable to North America, and then to UCMIS, the UK, the British mission to the United Nations. It contained legal advice and was intended to prepare the British delegation for the moment when the mandate actually terminated, so they would know how to answer any questions. And so you can see how I'm coming to this legal advice by a rather roundabout route. Well, E.M. Forster asserts in Howard's End that lawyers are a cold breed. And also law and justice are not quite the same thing. Far from it, in fact, but this talk is about law, not justice. And so I'm working with law. And among the advice in the telegram was the following statement that you see up there. No, don't go to this, thank you. The advice you see up there. If the Jews claim to set up a state in the boundaries of the Jewish areas as defined by the United Nations in the Partition Resolution, and the Arabs claim to set up a state covering the whole of Palestine, there would be nothing legally to choose between these claims. I will revert to this in a little while, but I've read them now to help you grasp the sheer enormity of what Britain left behind it. This was a legal vacuum, no more, no less. And the implication of a legal vacuum was that war was inevitable and nothing was being done to stop it. So let's go back to the Balfour Declaration. What political rights had Britain been obliged to ensure for the Arab people of Palestine? In fact, for all the people of Palestine. When the declaration was issued in 1917, it was only a statement of British government policy, but it promised that Britain would use its best endeavours to facilitate the establishment of a national home for the Jewish people in Palestine. It did not clarify what that meant, but the establishment of a national home was predicated on nothing being done that might prejudice, and you will remember Hanan Ashrawi referred to these words, the civil and religious rights of existing non-Jewish communities in Palestine. The Zionist leader Chaim Weizmann argued that civil rights referred to such matters as existing property and economic rights, and did not include political rights. This argument, as Hanan Ashrawi demonstrated for us, still gets aired, and British ministers and diplomats today inadvertently give credence to it by sheepishly stating that the declaration, it really ought to have included political rights. It was a shame it didn't. Yet contain political rights, it certainly did. And here I respectfully disagree with what Hanan Ashrawi said about this earlier. The problem has been that Britain did not make the true meaning of the words clear. Can we go to slide number 2, please? First, consider the word civil rights. Was the civil rights movement in America concerned only with property rights? Was it in Northern Ireland? Was it in South Africa? Of course not. The plain meaning of the word civil rights has to include political rights. Secondly, Palestine had already taken part in elections for the Ottoman Parliament. If you respect somebody's civil rights, how can you take away their right to vote? And thirdly, the fact that civil rights included political rights was effectively what the British government made very clear to its principal Arab ally, who, as Avi Schlein pointed out, it wanted on side. In January 1918, only 2 months after the issue of the Balfour Declaration, it sent Commander David Hogarth, a colleague of T.E. Lawrence, as an emissary to its ally, the Sharif Hussein of Mecca, and his task was to explain what the Balfour Declaration meant. The message he was given stated that Britain was determined that no obstacle should be put in the way of the ideal of the return of the Jews to Palestine, but wait for it, so far as is compatible with the freedom of the existing political and economic. Not just economic rights like property and freedom to do business, as Chaim Weizmann asserted, but political rights as well. So there you have it, from the horse's mouth. The Balfour Declaration had to be compatible with the political freedom of the Palestinians. But afterwards, to get back to what Avi said about British perfidy, when Hogarth reported back to his superiors, he used wording that hinted at British double dealing. He said that the Sharif Hussein would not accept an independent Jewish state in Palestine. He knew that, Hogarth knew that full well. But then he adds, nor was I instructed to warn him that such a state was contemplated by Great Britain. Can we go to the third slide, please? Let's look now at Article 22 of the Covenant of the League of Nations, which sets out the sacred trust of civilization that Britain was compelled to undertake. It's a lengthy text. I've only given you a short extract from it, but the point is it was legally binding, and the sacred trust on Great Britain was intended to ensure that the well-being and development of the people covered by the mandate would be assured. Now, everyone knew at the time that this meant preparing them for independence, and it was eventually confirmed many decades later, well after 1948, by the International Court of Justice. But Britain's obligation to prepare the Palestinian people for independence was clear and unequivocal. The other key legally binding text was the document setting out the terms of the mandate itself. It is a very strange piece of paper. It was largely Britain that drafted it, and it reflected British policy, as you might expect. Dr. Weizmann, the leader of the Zionist organization by now, was allowed to have substantial input into it, although he did not get everything he wanted. Yet no Palestinian or other Arab representative was given a similar opportunity. They were merely informed of its contents after it had been drafted. Nevertheless, can we now go to the next one, please, number 4. The document was intended to implement Britain's sacred trust of trust of civilization to the Palestinian people. This is clear from the very opening words. Whereas the principal Allied powers have agreed for the purposes of giving effect to Article 22 of the Covenant of the League of Nations. Now, these preambular paragraphs beginning whereas, which lawyers seem to love so much and try to put them always in at the beginning of a document, are known as recitals in the trade. They set out the intention behind the document and are used to interpret its meaning. They are not therefore merely waffle, they matter. And so this reference to Article 22 mattered. The Palestine Mandate was meant to fulfill that sacred trust of civilization. But let's carry on to the next recital. And I will read this one slowly and carefully because it's rather longer. Whereas the principal Allied powers have also agreed that the mandatory, that is to say Britain, should be responsible for putting into effect the declaration originally made on the 2nd of November 1917 by the government of His Britannic Majesty and adopted by the said powers in favour of the establishment in Palestine of a national home for the Jewish people. It being clearly understood that nothing should be done which might prejudice the civil and religious rights of existing non-Jewish communities in Palestine, or the rights and political status enjoyed by Jews in any other country. So you see, the civil rights, including the political rights of the Palestinians, were preserved in the mandate, even though prominence is given here to the establishment of the national home. And then it carries on. Whereas recognition has thereby been given to the historical connection of the Jewish Palestine, the Jewish people with Palestine, and to the grounds for reconstituting their national home in that country. So that is yet it's a third recital. And remember, the whole document is interpreted to give effect to these ideas. I'm not going to read you the rest of the document, but let's look at Article 2 briefly. It obliged Britain to place Palestine under such political, administrative, and economic conditions as will secure the establishment of the Jewish national home as laid down in the preamble, and the development of self-governing institutions, and also for safeguarding the civil and religious rights of all the inhabitants, irrespective of race or religion. Reading all these things together, you cannot get away from Britain's sacred trust of civilization to the Palestinian people to prepare them for independence, but it also bound itself to facilitate the establishment of the Jewish national home in Palestine. In fact, most of the rest of the text of the mandate, which I haven't quoted here, is concerned with facilitating the establishment of the national home. Yet what if the Palestinians did not wish their country to become the national home for the Jewish people? And Britain knew full well that they did not, if that meant that incomers would take their country over from them, which, frankly, was what Weizmann and Ben-Gurion and similar leaders intended. And Britain had also been warned, and I don't go into this here, I'm not going to go into this now, but also Britain had been warned very clearly that the establishment of the national home could only be accomplished by force of arms. Nevertheless, Britain still had, as you can see in Article 2, the obligation to grant to the Palestinian people self-governing institutions in which they could have expressed their views. Excuse me. Britain never did this. This failure came in for censure very rapidly from the Mandates Commission at the League of Nations in Geneva in 1924. And as a recent book by the scholar Penny Sinanolu, who has recently produced an exhaustive study of Britain's various proposals to partition Palestine, has pointed out, the mandate was unworkable so long as Jews and Arabs could not be brought together in a joint representative legislature. But it was Britain's task, it was Britain's solemn duty to achieve that, and it did not so. As the historian Martin Gilbert has pointed out, I think Avi Schlein quoted from him, and there are many other historians who will say the same thing. It was a centerpiece of British policy to withhold representative institutions in Palestine until such time and there was a Jewish majority. And this was also the policy of the mainstream of the Zionist movement. To paraphrase something else Sinanolu says, while Britain provided the international scaffolding for Jewish nationalism in Palestine, it not only failed to do the same for the nationalism of the Arabs of Palestine, but actively suppressed it. Britain, in pursuit of its own imperial interests, had of its own free political will put itself in a position where it had given itself a circle to square. Throughout the duration of the mandate, it was unable to establish the representative institutions it was bound to establish by Article 2, but the Jewish community in Palestine, the Yishuv, fiercely opposed the creation of such institutions, as I've already mentioned, but nevertheless, it established its own democratically institutions, which were solely for the Jewish community. So that was the position in Palestine. By contrast, in all of the neighboring Article A mandate territories, Iraq, Syria, and Lebanon, to which the sacred covenant of Article 22 also applied, self-governing institutions were established. And the same applied in Transjordan, that was technically part of the Palestine Mandate. By 1946, these countries had elected parliaments and were fully independent with constitutional forms of government. Could we go to number 5, please? Let's go back to that legal advice now and look at what happened at the end of the mandate. If the Jews claimed to set up a state, in the boundaries of the Jewish areas as defined by the partition resolution, and the Arabs claimed to set up a state covering the whole of Palestine, there would be nothing legally to choose between these claims. And I come here to a very important point. It is often wrongly suggested that the UN partition plan passed by General Assembly Resolution 181 on the 29th of November 1947 set out what was intended to be a binding settlement between the Yishuv, the Jewish community, and the Palestinian Arabs. But that was not quite so. And that is why the legal advice stated that there would be nothing legally to choose between the two claims. A Jewish claim for a state within the areas allocated for it in the partition plan, and an Arab state in the whole of Palestine. There would be nothing legally to choose between these two claims. And the reason for this was that the partition plan was always provisional. Up to the last few days of the mandate, there was always the possibility of a US-led U-turn, which would have scrapped partition in favor of turning the whole of Palestine into a UN trust territory, the successor to the League of Nations mandate. This was actually one of the greatest fear of David Ben-Gurion and the other political leaders of the Yishuv. But Britain's concerns were not for the people of Palestine, but to secure as orderly withdrawal as possible for its own forces and administrators, and to leave Britain's position and prestige in the wider Arab world intact. As a General Assembly resolution, the partition plan was only a recommendation, a suggestion, basically. It could have been made binding by a Security Council resolution, but there was no majority to do this on the Security Council, so the issue was never put to a vote. The steps towards implementing it were never taken, and Britain refused to cooperate with the UN Commission that was meant to be in charge of doing so. Britain has been damningly described by the legal scholar John Strawson as too weak to prevent the civil war that broke out, but strong enough to frustrate the UN plan. Can we go to slide 6, please? Foreign Office legal advice accurately stated on the 14th of May, therefore, that if a Jewish state is proclaimed, it will be setting itself up by its own efforts and not through acts of the UN Commission. Much activity towards setting up the Jewish state had already taken place before Israel declared its independence. The Yishuv's own parliament, the Va'ad Yeloimi, had well-organized departments dealing with matters such as education, health, and labor. These provided the services to the Jewish population that were expected from a government. They had experts such as economists, agronomists, statisticians, surveyors, you name it. In reality, they had their own armed forces, which had reached the levels of sophistication that they had their own military lawyers, while the Jewish agency acted to all intents and purposes as a Ministry of Foreign Affairs. The Arab Higher Committee that was treated by Britain and the UN as the representative of the Palestinian people had almost nothing by contrast. It had no democratic legitimacy, as it had never been elected, and it had no armed forces. The Palestinian Arab population had no choice but to rely on the government provided by the British mandate for its security and for all the services a government was meant to provide. Now that government would cease to exist. You saw what happened to the people in the photos that Roger Hardy has just shown us. Relatively few who had passports issued by the mandate government would now find them worthless. Palestinians would now have no army or police to protect them. There would be no budget, no education, or health services, no currency. The Palestinians would become a stateless people. Such was Britain's legacy. According to Menachem Begin's memoirs, Irgun and Haganah commanders had met at the end of January 1948 to plan the conquest of what is today most of Israel and the northern West Bank. By early April, about 6 weeks before the State of Israel was proclaimed, the armed forces of the Yishuv were relatively certain that the British, whose departure was now well underway, would not interfere with what they did very much, and so they went on the offensive. They feared international support for partition might weaken, and they needed to secure the territory of what would become the State of Israel. The Haganah commanders had concluded that, quotes, war is war, and there is no possibility of distinguishing between good and bad Arabs, unquotes. On the eve of the offensive, Ben-Gurion said, "We shall enter the empty villages and settle them." Slightly earlier, on 20th of March, a representative of the Jewish Agency had told the London Times that the Jews of Palestine have already put a sort of partition into force, and we are maintaining it. Benny Morris, the historian, is of the view that by the first half of April, the Yishuv was engaged in a war of conquest. Before the proclamation of the State of Israel, 13 operations to secure Arab strategic areas had already taken place. Not all had been successful, but the orders for all of them were issued pursuant to the Haganah's Plan Dalet, which envisaged that where necessary in order to secure the state, the inhabitants of the area concerned would be expelled outside its boundaries. The Anglo-Palestinian scholar Victor Catan, whose researches carried out for his book From Coexistence to Conquest have been invaluable for me in writing this paper, has pointed out that 8 of those 13 areas for operations were outside the areas earmarked by the partition plan for the Jewish state. The Yishuv claimed to accept the partition plan, but it did not implement it. It contravened it. In fact, the partition plan made war inevitable. Up to half the Palestinians who were made refugees had lost their homes on Britain's watch, including Ghada Karami, who we heard from earlier, before the State of Israel was even proclaimed. This is confirmed by analysis from the Israeli Defense Forces, the IDF. Palestinian society quite simply disintegrated, and Britain let this happen. Britain, I remind you, was still responsible for the security of the people of Palestine, of whatever faith or ethnic group. Rashid Khalidi has observed that, as the mandate approached its end, Arab Palestine was crumbling, and the implications of the absence of a single Palestinian national authority that could have raised and organized forces to defend it were now acutely clear. As individual cities, towns, and villages, most defended by their inhabitants with scant help from outside, fell to the well-organized centralized forces of a state that had not yet been declared. Can you go to the final slide, please? When Israel declared its independence at midnight on the 14th of May, the civil war turned into an international conflict as 4 Arab states intervened, as governments felt pressured by public opinion to go to the aid of their Palestinian brothers and sisters. But all these governments followed their own self-seeking and conflicting agendas, something that Avi Schlein gave us a glimpse of. For its part, Israel immediately filed an application to become a member of the UN. This was rejected without even reaching the Security Council floor. Why was this? As the legal advisors in the British Foreign Office put it, put it 4 days after the mandate ended, The present juridical situation as regards Palestine is obscure, and we cannot be sure whether other governments besides that of the Jewish state will emerge. It would be unfair and legally wrong in the circumstances to admit the Jewish state to the United Nations at this early stage, and thus to give it international recognition, while not taking any similar steps for the rest of Palestine. What an admission by the legal advisors to the outgoing mandatory power. Very significantly, the Foreign Office legal advisors also argued against recognition of Israel because, for the time being, it did not, in their view, fulfill, quotes, the basic criteria, unquotes, of an independent state. Chief among these was the fact that it did not yet exercise effective control over the territories it claimed. Right, I said that was the last slide, but it's not. Can you please now go to the last one? So how did Israel come into existence as a state, since this did not happen as a result of the partition plan or a decree by the UN? The answer is by an act of secession. Secession in international law has been authoritatively defined by Judge Crawford, who very sadly died not so long ago, as the creation of a state by the use or threat of force without the consent of the previous sovereign. In the case of Israel, that force and the threat of its use had been exercised against the majority of the native people of the land, because there was no way it could come into existence unless it used force to take control of what would become its territory. In other words, it had to conquer that territory. One of the tests for when it became a state was met when it established a stable and effective government there. It had certainly reached that point by the 24th of February 1949, when it signed an armistice with Egypt. But although it was immediately recognized after its declaration of independence on a de facto basis by the USA and Britain both opposed Israel's initial application to become a member of the UN. A second application was also rejected on the 17th of December, although this time the USA voted in favor. Nevertheless, it would only be on the 31st of January 1949 that the USA recognized Israel's de jure status, gave it de jure recognition. And it would seem this only recognized Israeli sovereignty over the areas earmarked for the Jewish state in the partition plan. Israel would have to wait until 11th of May that year to be admitted as a member of the UN. From that date, there has been no doubt about the legitimacy of the state of Israel in terms of international law. British de facto recognition followed 2 days later, and de jure recognition on the 28th of April 1950. And what of the other areas of Palestine? The West Bank, which includes East Jerusalem, incidentally, was unilaterally incorporated into its territory by Jordan in late 1948, but has never achieved international recognition. Britain had left chaos there too. That chaos can be exemplified by the fact that one of the last acts of the mandatory government had been to repeal Britain's Palestine Defence Emergency Regulations of 1945, which Michael Link will talk about tomorrow. But although Britain intended to repeal them, those regulations, and took steps to do so, Jordan was actually unaware that this had occurred, and consequently duly enacted its own legislation to repeal the regulations on the land it purportedly incorporated into Jordan. That is another incredible example of legal chaos left behind by Britain. Finally, what is now the Gaza Strip came under Egyptian military occupation and was militarily occupied territory. Then in 1967, the people of Gaza would find themselves living under a new military occupier, Israel, which took possession that year, and in international law remains the occupying power to this day. To conclude, Britain failed its sacred trust of civilization towards the Palestinian people. Instead of the well-being, development and independence which it had promised, it left them with a legal vacuum, chaos, war and dispossession. It carries responsibility for all of these, and it is far too little remembered in Britain today. To rectify this amnesia is one reason why this conference is taking place. It is Britain's duty to acknowledge that responsibility, our British responsibility, and to work now to advance equal rights for all in what was the British Mandate of Palestine. Those rights include self-determination and mutual security. It is clear today who has self-determination and mutual security and who does not. Thank you all very much.
Thank you very much indeed, John. And thank you to Roger for the earlier presentation.